Hello, my name is Pauline Collins, and I would like to thank Professor Michael Lower, Vivian Chen, and the organising committee at the Chinese University of Hong Kong Law Department for organising this amazing online conference on teaching and learning in law. And I'd particularly like to thank the Stoic Stayers for their presence at this presentation. Today's legal practitioners are adjusting to a different type of legal professional practice that requires a very different style of lawyering. This new professional is required to use communication not as a strong partisan advocate, winner takes all, but rather to advance their client's interest in a holistic and a collaborative manner that sustains relationships and satisfies wider interests than just monetary ones. McFarlane has described it as a seismic change from adversarial advocacy to conflict resolution advocacy. The dilemma for the law student is that much of their law school curriculum still focuses on adversarial advocacy. A further dilemma is the perpetual divide between doctrinal or theory and skills teaching. Despite being well documented, this is a false binary. This can present as a major block to adoption of a holistic approach to teaching dispute resolution in a law school and makes the task of the dispute resolution teacher so much harder. Adapting to the collaborative over a rights-based communication approach can be very difficult. It requires both allowing greater ownership in disputes and their resolution by the parties, as well as a recognition of the importance of needs and interests beyond mere rights. Students have likened the difference in approach as to wearing two different hats. Encouraging lifelong learner skills and preparing students for a new style of lawyering in the 21st century to meet these changing needs means teaching in renewed ways. This presentation will describe the action reflection learning approach adopted when teaching a dispute resolution course. As a female professor, I tend to adopt unique assessments, and these I find indicate a style of teaching that bridges the false divide between doctrine and skills, but more particularly adversarial and collaborative legal training. My experience is this has enriched the students' learning. However, it is not without its challenges in satisfying the many masters in the current law school and university environment. Australian law students are required to attain a threshold of learning outcomes called TLOs. There are 6 of these, and TLO 6 is called self-management, and this requires a reflective capacity as a core skill. It is expressed as an ability for students to reflect on and assess their own capabilities and performance and make use of feedback as appropriate to support personal and professional development. This is an interesting requirement in law curriculums as those curriculums we all know allow little space for ensuring the time needed to engage students in both action learning and assessment and reflective practice. And this is despite the acknowledgement from the TLOs of the necessity of this skill. Even calling it a skill throws up the dilemmas as it raises the aforementioned perpetual division of doctrine and skills teaching. And much has been written about the hierarchical division between the heroic doctrinal teacher and the lesser vocational skills trainer. In the US, Jewell has described how this reinforces the development of doctrinal professors on one level, aiming to distinguish themselves from the earlier vocational professors who were often practitioners and now seen as clinical legal skills teachers. This has been written about as a gendered problem, with the vocational skills trainer being seen as lesser in the hierarchy and a position often filled by females. I see this a little differently, interestingly, as a female professor, but also a practitioner mediator. I'm teaching a first-year undergraduate course that has both theoretical and skills combined approach. I guess some of the discussion, though, is borne out when it's considered that I'm the only female professor in the school still teaching a first-year core course, often referred to as a skills course. However, I integrate doctrinal theory along with the skill development, approaching the teaching as a praxis, that is a holistic integration of what to do and why one is doing it, and understanding the theoretical consequences and import if one is not doing as one should. The research done by Schultz and Zedek in the US on law school admissions, which was based much as in Australia on an academic proficiency or merit score, provides another avenue for considering the law school role. Schultz and Zedek propose a better professional competency scoring process that has greater predictability for producing more competent and professional lawyers. Their extensive research showed that an ability to address 26 lawyer effectiveness factors was essential. These were focused, guess what, around communication, which is something that dispute resolution teachers engage with extensively. And they included areas such as ability to listen, self-organize, manage one's time, creating healthy relationships, and being able to use empathetic abilities. And these all provide for a more successful professional lawyer outcome in their findings. My course supports a self-management approach in learning that enables students, by adjusting after feedback and reflection, to appreciate the development in their capability and skills, such as listening, communicative ability for better relationships, and acknowledging of emotions. Thus, it attempts to satisfy the TLOs and the professional accreditation master's demands. As noted, the teaching in legal conflict resolution approaches skills and theory as holistic, single, not disparate concepts. While this would appear to require students to be present face-to-face, we have enabled online participation in role plays. Assistant teachers are generally required to circulate and ensure all participants are receiving appropriate guidance and feedback in a role play activity teaching session, whether that be face-to-face or online. This is seen as creating a more expensive resource-intensive course, because if the assistant is paid, it will cost more. However, often they do it out of love and just assist. But economic efficiency is obviously one of the requirements of the new university. So these realistic role play scenarios enable groups of 3 students to perform mock mediations. 4 mediations are conducted of around 90 minutes each over a period of 2 days. And this goes beyond problem-based learning that relies on adopting solutions centered on past experience to instead follow an action learning, acting upon reflecting, simulating simultaneously their learning, but requiring reflection on practice both during and after the activity. So action reflection learning allows assessors to set tasks that incorporate the elements of reflection, include some form of real problem. So sometimes it can be misinterpreted as problem solving, but the experience has to relate to the participants' professional context, multiple participants, a range of potential responses, and mostly for reflective learning, the opportunity for reflective action, both individually and in the group, and with an action expert learning coach. Of the 4 schools up there on the slide of action learning, the latter is adopted in my law course, namely critical reflection. And this is because I like Frere's notions of praxis, in which practice is purposefully integrated with the theory, and that supports my approach. Critical reflection involves addressing the context in which the problem arises by challenging assumptions, encouraging alternative approaches, and inducing an empathetic appreciation of the consequences of action as they affect outcomes and other parties, a requirement that has been noted by Schultz and Zedek as in greater need for law practitioners. Rogers has there given a 4-step guide to reflection, which I won't go through. Each of these aspects are present for the law students when learning a new communicative process through active application in a group mediation role play. The group reflective exercise brings together people who have a shared knowledge, goals, and attitudes that support student learner self-assurance using the knowledge achieved by action reflection. And this can result in a change of behaviour and ability to lead and adapt to change as the approach instills a confidence in students' ability to transition to professional practice. So the assessment in this course attempts to accommodate these demands. With these in mind, the role play mediations challenge students that have been put through a scaffolded, structured, prior learning experience, starting with the relevant theory, then learning the mediation process, and then these come together in the final combining of the two in the praxis. There are a number of opportunities for reflection that are provided, at least 3 points throughout the course. One of the main assessment items is a reflective written assessment worth 35%, requiring the students to document and respond to 2 or 4 role plays occurring over the 2-day intensive. Having learned the theory, processes and skills in the scaffold of prior sessions, the students are required to identify how this informed their experience by reflecting on the links between theory and action in the written assessment. Beyond the individual and role play group reflection, the whole class comes together to share their learnings at the end of each role play in an overarching debrief that adds to the diversity of voices to create more thought-provoking insights in the moment. Going back to the original written assessment, this provides a means to view the experience through a more contemplative lens. In a holistic manner, the praxis experience relates current knowledge to past learning to create new learning. This can prompt conscious changes in behaviour based on a deeper reflective understanding of when to use what skills and why, based on the theory. The predominant emphasis on rights-based adversarial lawyering is directly challenged through this experience. It encourages students to question their worldview and assumptions, providing a social consciousness. The following reflections, just a couple from the students, indicate this awareness. One said, "I've always been a listener and now I understand something of why that can help others." Another said, "This course really allowed me to alter my thinking with regards to resolving disputes. I've come to learn that winning isn't everything." So the coach also in this is very important and facilitates learning by using guiding questions and interventions that focus attention on what is achieved well and what still needs to occur. The coaches model a mediation or conflict resolution approach and use that language to empower the students by creating a safe environment. They're not actually assessed on their role plays, so they are free to learn by mistake. And this is supported by clear direction and criteria, guiding the students towards their desired learning outcomes. A final reflection in a group post-action forum at the end of the course helps the students appreciate their most momentous learnings and why they are significant. It moves beyond the description of an active learning exercise to question students' ideas and the fundamental motivations in their worldview through their own self-critique. It demonstrates how the action-reflective approach has assisted in overcoming Freire's concerns with breaking free of the oppressive. A metacognitive awareness involves thinking about thinking in an active cognitive approach in which the self observes while also acting all the senses through all the senses in the role play. The assessment and teaching provides the students with an opportunity for making deep connections required for a lasting and profound awareness in order for their professional selves to appear. Students describe this learning as authentic, real-world experience. The application of the law, they say, is very different to the textbook learning approach. And one said, "It's hard to imagine what the practical process of doing law is when we're studying it. I've gained a greater understanding of the theory by actually putting it into practice." Another said, "I have now gained the knowledge of why and how we do what we do to reach a positive outcome for our clients." So teaching reflective practice throughout the curriculum assists students develop their professional capacity as the practice becomes ubiquitous. However, this can be challenging for law students who are habituated to learning through the IRAC or issues rule application method, and summative assessment based on such an approach can fail to establish a lifelong learning approach that enables self-awareness of any gaps in knowledge and skills. Reflection involves empowering students to take more responsibility for their learning, and without this, students risk becoming dependent on external rewards. This further benefits them by including the potential to assist law students who we well know are afflicted by anxiety or depression. Summative assessment can create a negative self-perception and is often experienced as separated from the learning process itself. Reflective action learning assists developing graduates' flexibility and adaptability in responding to the context, developing their emotional intelligence and recognition of mental patterns, dialogue, and personal interactions. It also teaches the skills of self-regulation alongside core content knowledge. Reflexive questioning creates a meta-awareness of how one's dialogue affects others, including whether it can escalate or de-escalate conflict. The skill is critical to survival of not only the individual, but also organizations operating in the 21st century, with challenging environments, new technologies, and flexibility being constantly demanded. Integrating a reflective approach throughout the course, both in a formative and summative manner, develops the lifelong learner and creates a metacognitive aware professional practitioner who is more likely to resist oppressive practice, to become an informed, flexible, and adaptive lawyer. Including the student instead of just the teacher in the assessment process intensifies this learning. As a female teacher, I've brought my priorities on reflection and communicative ability concerns into the course design. The process, however, can still be challenging for teachers as it requires insights and perseverance against some of the pushback from schools and universities focused on cost and student opinion audits. You can read some of the outcomes here, and I'll leave it now for some question time. Thank you for listening today.